Hello friends, in today's session we are going to discuss a case Mr.Jugal Kishore Prasad versus State of Bihar AIR 1975 Supreme Court 2522. This case related to Section 6 of the Probation of Offenders Act. Section 6 comprises two subsections 1 and 2. Subsection 1 states that when a person below the age of 21 is found guilty of an offence punishable with imprisonment except for life imprisonment, the court must ensure before sentencing them to imprisonment that considering the circumstances of the case, including the nature and character of the offence, it is not desirable to deal with the offenders under Section 3 or Section 4 of the Act. If the court decides to sentence of offenders to imprisonment, it must record the reasons for such a decision. Subsection 2 states that for determining whether it is undesirable to deal with the offenders under Section 3 or Section 4, the court shall seek a report from the probation officer and consider the report, if any, along with the other information related to the character, physical and mental condition of the offenders in the case. The appellant and 5 other co-accused were charged under various sections of the Indian Penal Code, Section 147, rioting, Section 148, rioting arms with deadly weapons, Section 307, attempt to murder, Section 323, voluntarily causing hurt, Section 326, causing grievous hurt by dangerous weapons, read with Section 149, unlawful assembly, committing on offence. Now let's delve deeper into the study of this case. Subject of the case. The case pertains to Section 6 of the Probation of Offenders Act 1958. The main question was whether the appellant, who was convicted under Section 326 and Section 149 of the Indian Penal Code IPC and was under 21 years of age at the time of sentencing, could claim the benefit of the Probation of Offenders Act. Fact of the case: the appellant and 5 co-accused were charged with committing a collective crime in Mandil village, district Gaya. The charges against the accused included under Section 147, rioting, Section 148, rioting with deadly weapons, Section 307, attempt to murder, Section 323, voluntarily causing hurt, Section 326, voluntarily causing grievous hurt by dangerous weapons, read with Section 149, unlawful assembly. Additionally, the accused were charged under Section 25 of the Arms Act. The trial was held in the court of the Additional Session Judge, District Gaya. The appellant was found guilty under Section 326 and Section 149 and was sentenced. At the time of sentencing, the appellant was under 21 years of age. Trial court. The Additional Session Judge found the appellant, Shri Jugal Kishore, guilty under Section 326, read with the Section 149 and Section 148 of the IPC. He was sentenced to 5 years of the rigorous imprisonment for the first offence, Section 326 with Section 149, and 2 years for the second offence, Section 148. Both sentences were ordered to run concurrently. 5 other co-accused were also convicted and sentenced for various offences. High Court. On January 22, 1968, the Patna High Court acquitted two of the accused but upheld the conviction of the appellant under Section 326, Section 149 and Section 148 of the IPC. The court reduced the appellant's sentence for the offence under 149, read with the Section 326, from 5 years to 3 years, but retained the 2-year sentence for Section 148. After this decision, the appellant applied for the benefit of the Probation of Offenders Act 1958, arguing that since he was 21 at the time of sentencing, he would be entitled to the provisions of the Act. On December 12, 1968, the High Court was rejected the application, stating that since the offence he was convicted was punishable by the imprisonment, the provisions of the Probation of Offenders Act could not apply. Supreme Court. The appellant then approached the Supreme Court, raising the issue of whether the Probation of Offenders Act was applicable in his case. After examining the provisions of the Act, the Supreme Court expressed the view that if an offence was committed by the person under 21 years of age and the offence was not punishable by the life imprisonment, then the court should not impose a custodial sentence without considering corrective measures. The court emphasized that the circumstances of the case and the character of the offender should be considered before deciding on a prison sentence. If the court decides to impose a prison sentence, it should clearly record the reasons for doing so. Additionally, the court should consider whether corrective measures under Section 3 or 4 of the Act could be applicable. The court referred to the case of Somnath Puri versus State of Rajasthan, AR 1972, Supreme Court 1490, where the applicant was convicted under Section 409 of the IPC. The court observed that the punishment of the offences under both Section 409 and Section 326 is similar, that is life imprisonment or up to 10 years of the imprisonment with a fine. In this context, the court concluded that an establishment in the Somnath Puri case, the benefit of the probation under Section 4 of the Probation of Offenders Act cannot be claimed for such serious offences, as both offences are of a grave nature and attract severe penalties. Judgment. The Supreme Court dismissed the appeal. Legal principles established. Objective of the Probation of Offenders Act 1958. The Act was enacted to keep young offenders away from the company of the hardened criminals. Its goal is to ensure that young offenders do not turn into habitual criminals and that their chances of rehabilitation remain intact. Second, context of reformative justice. Modern criminal jurisprudence hold that no one is born a criminal and people commit crime due to social and economic circumstances. The Probation of Offenders Act was implemented based on this ideology, giving the courts the discretion to consider corrective alternatives for offenders under 21 years of age, whose offences are not punishable by life imprisonment, before imposing a prison sentence. Application of Section 6 of the Probation of Offenders Act. Under Section 6 of the Probation of Offenders Act, offenders under 21 years of age who commit offences not punishable by life imprisonment can benefit from provisions of the Act. This holds true even if a lesser punishment could have been imposed for the offences. The nature of the offence is crucial in determining whether the offender can be considered for probation. Thank you.